Litigation has long been one of the most persistent and damaging problems confronting the judicial system. Civil disputes relating to the property, contracts, family matters, and commercial transactions frequently remain of even decades. This prolonged adjudication undermines public confidence in the judiciary, increase the litigation cost, effective denies parties timely justice, and the famous legal maxim "justice delayed is justice denied" encapsulates the gravity of this issue. The Code of Civil Procedure 1908 has enacted objective of establishing a uniform and efficient procedural framework for adjudicating civil disputes. However, over time, procedural complexities, excessive technicalities, and tactical misuse of procedural provisions contributed significantly to systematic delays. Recognizing the urgent need for reform, the legislative undermines major amendments to the CPC in 1998 and 2002. These amendments aim to curtail procedural abuse, streamline the litigation, and ensure expedient disposal of civil cases. This paper critically examines the impact of these amendments on delay reduction in Indian civil courts, evaluating both their achievements and limitations. Now, we will discuss about the nature and cause of delays in civil litigation. The problem of delay in civil litigation is multifaceted and deeply entrenched. One of the primary causes of the liberal grant of adjournments, often without sufficient jurisdiction. Parties frequently seek repeatedly invest in inevitable outcomes to exhaust the opportunity or to exhaust the psychologically of the victim. Courts burdened with heavy caseloads and constrained by procedural acquires such request. Another significant factor contributing to the delays is the absence of strict timeline for procedural stages such as filing the pleadings, records of the evidences. The defendants commonly delayed filing written statements while plaintiff often sought time-consuming amendments and inter-applications, resulting in the prolonged pre-trial stages. Furthermore, inadequate judicial infrastructure of judges and administrative inefficiencies compounded the problem, leading to massive pendency across all levels of the judiciary. From a constitutional perspective, delays in judicial proceedings directly infringes the right to speedy justice, which has been recognized as an integral component to the right of life and personal liberty under Article 21 of the Constitution. That also we can see in the case of the Husainara Khatun versus State of Bihar. The Supreme Court category the held the speedy trial is a fundamental right, thereby elevating procedural efficacy to the constitutional statutes. Consequently, persistent delay in civil courts amount to a violation of constitutional guarantees necessitating urgent legislative and judicial intervention. Now, we will discuss about the legislative intent and objective of the CPC amendments. The CPC amendments of 1999 and 2002 were introduced against the backdrop of increasing dissatisfaction with the pace of civil litigation. The Law Commission of India, through its various reports, including 77th, 79th, 99th, 163rd, and 177th report, repeatedly emphasized the urgent need to simplify the procedures of the court, imposes the time limits, and enhance the judicial control over the litigation. The primary objective of these amendments can be summarized as follows. The first primary objective is to ensure the speedy disposal of the civil cases by introducing the time-bound procedures. Second is to prevent abuse of procedural law and discourage the dilatory litigation tactics. Third is to strengthen the judicial case management and enhance the court control over the proceedings. Fourth, to promote early settlement of disputes through alternative dispute resolution, that is ADR mechanism. To reduce Fifth point is to reduce the pendency, restore public confidence in the delivery system. These objectives reflect a conscious shift from a purely adversarial and party-driven procedural framework to a more protective, judge-centric model aimed at achieving procedural efficiency and substantive justice. Now we will discuss about the key procedural reforms and their impact. First key procedural reform is the restriction on adjournments. One of the most significant reforms introduced by the CPC amendments pertains to restraint on adjournment under Order 17 Rule 1. Prior to the frequently granted adjournments on the routine grounds, often without recording reasons, resulting in prolonged trials. The amendment provisions restricts the number of adjournments to a maximum of the three of each party during the entire course of the suit, and even these upon showing the sufficient cause. Time limits for filing the written statements. This amendment to Order 8, Rule 1 introduced a strict timeline for filing the written statements. Under the amendment provisions, the defendant is required to file the written statement within 30 days from the date of service of summons, extended to 90 days only in exceptional circumstances. This reform addressed one of the most common tactics employed to delay litigation, namely prolonged delay of the pleadings. In Kailash versus Nanku, the Supreme Court clarified that the Supreme Court, while the provision is directory rather than mandatory, courts must enforce it with firm and disciplined approach. Extension should be granted only in exceptional cases to prevent the miscarriage of justice. The balanced interpretation ensures that procedural disciplines is manifested without sacrificing the substantive fairness. The introduction of time has accelerated the pre-trial phases, enabling early framing of issues and performing the commencement of trials. Now we will discuss about the judicial case management and pre-trial procedures. The amendment significantly enhanced judicial cases management power through modifications. In Rule 10, 11, and 15A, the courts are now empowered to scrutinize pleadings at an early stages. Identified dispute resolution, the shift marks a transition from party-controlled litigation model to a judge-driven framework where court actively supervises the case progression. In Afghan Infrastructure versus Chetan Varki Construction and Corporation, the Supreme Court emphasized the importance of judicial intervention in managing the cases effectively. The court observed that the proactive judicial control is indispensable for reducing backlog and ensuring the timely justice. By enabling early identification of issues and structure schedule, these reforms have enhanced procedural efficiency and reduced the unnecessary delays. Now we will discuss about the strengthening of discovery and admission procedures. The amendments in Order 11 reinforce the provision relating to discovery, inspection, admission, and delaying of documents. Early disclosure of relevant materials prevent trial by ambush, narrows the scope of factual disputes and facilitate quicker resolution. The admission reduce evidently burdens and enable courts to focus genuinely on the issues related to expediting trials. This reforms enhances procedural transformance and fairness while simultaneously contributing to efficiency. By limiting the scope of factual controversy, court can significantly reduce the duration of trials and avoid the unnecessary examination and witness. Now we will discuss about the evidence of affidavit and regulation of oral testimonies. Another major reforms in the introduction of affidavit-based examination in chief under Order 18 Rule 4, traditional recordings oral evidence conquered considerable judicial time by requiring multiple hearings. By permanenting the examination in chief through affidavits, court can substantially reduce the duration and reserve the proceedings primarily for cross-examination. This reforms not only saves the judicial time but also enhances the clarity and efficiency. It enables court to handle a larger volume of case within limited time frames, therefore contributing to the delay reduction. Now we will discuss about the imposition of realistic and deterrent cost. The amendment strengthened the cost regime under Section 35 and 35B by empowering courts to impose realistic and the frivolous litigation and procedural misconduct. Historically, nominal court failed to deter abuse of parties' litigation without strong financial consequences. In Salim Advocate Bar Association, the Supreme Court emphasized the necessity of imposing actual and realistic costs to discourage dilatory tactics. The strengthened cost framework promotes responsible litigation behavior and reduces the incentives for procedural abuse, thereby enhancing the procedural disciplinary disciplines. Now we will talk about the promotion of ADR, that is Alternative Dispute Resolution. Section 89 of the CPC introduced statutory recommendation of ADR including arbitration, mediation, conciliation and settlement. Courts are mandated to explore the possibility of settlement the pre-trial stage and refer suitable case to the ADR process. Conclusion. The CPC Amendment of 1999 and 2002 represent a landmark intervention in India's civil procedural law aimed at curbing delay, enhancing judicial control, and promoting the speedy justice. By restricting adjournments, imposing time limits, strengthening the discovery, regulating evidence, promoting ADR, and introducing the realistic cost mechanism, these reforms have significantly improved the procedural discipline and efficiency. However, procedural reforms alone cannot fully address the complexity challenges of judicial delay. Sustainable improvement requires a holistic approach encompassing judicial capacity, building infrastructure development, administrative modernization, and technological integration. Only through coordinated institutional reform, constitutional promise to timely justice be fully realized. Thank you so much.